Welcome to this week's Property Elite podcast. Stay tuned each week for industry hot topics, market updates, and new RICS guidance. Understanding the impact of the Renters' Rights Act 2025 is essential knowledge for residential candidates pursuing leasing and letting, landlord and tenant, or property management as a technical competency, or for commercial real estate candidates who are managing mixed-use properties. In addition, if you rent a property personally, then make sure you know what your rights are under the new legislation. The 2025 Act represents the most significant policy reform in the private rented sector for years. It introduces a wide number of changes, which will affect landlords, tenants, agents, and surveyors. The aim of the Act is to create a functioning private rented sector that will provide a secure stepping stone for aspiring homeowners and flexibility for those who want it. This should help create a better balance between landlords and tenants without undue regulation and control on the market. So what changes under the Act? Prior to the implementation of the 2025 Act, there are two ways to gain possession of a property rented out on an assured short-hold tenancy. Section 8 of the Housing Act 1988 is used where the tenant has breached the tenancy, whereas Section 21 of the 1988 Act is used for a no-fault eviction. The latter does not require the tenant to have breached their tenancy and allows the landlord to regain possession at the end of a fixed-term AST or during a periodic tenancy. No reason needs to be given, as long as at least 2 months' notice is served. The first phase of the Act will be implemented on the 1st of May 2026. This will apply to tenancies where the tenant enjoys exclusive occupancy of the entire property or a specific room within a property. The property is the tenant's main home, the rent is between £250,000 and £100,000 per annum, and landlord does not live at the property with the tenant, and the tenant is an individual, not an organisation. The key reforms are: Section 21 is abolished, so no-fault evictions can no longer be triggered by landlords. Thus, Section 8 must be relied on, requiring specific grounds to be stated, such as rent arrears or damage to the property. The mandatory eviction threshold for tenant arrears has been increased from 2 to 3 months, and the notice period must be at least 1 month in these circumstances. For antisocial behaviour, the landlord can begin proceedings immediately. A landlord can seek possession under Section 8 if they are selling the property or wish to take back the property for their own occupation. A landlord cannot do this within the first 12 months of a tenancy and must give the tenant 4 months' notice. They cannot market or re-let the property for 12 months if a tenant is evicted under this ground. All ASTs will become periodic rather than fixed term. Tenants will be able to terminate an AST at any time, only giving 2 months' notice. There is no phased implementation of the 2025 Act, so all the changes take effect on the 1st of May 2026. Some additional changes under the Act include: rents can only be increased 1 each year after serving a Section 13 notice, again under the 1988 Act, giving 2 months' notice. The proposed rent must reflect a market rent, and tenants can challenge excessive proposals via the first-tier tribunal. When marketing a property to rent, an advertised rent must be stated, and no offers may be accepted above this advertised rent by a landlord, and this effectively bans bidding wars. Rules to prevent discrimination against tenants with children or who are in receipt of benefits. Specific wording must be included in all ASTs from the 1st of May 2026, including but not limited to mandatory information such as the name of the landlord, name of the tenants, property address, start date for possession and the rent. Landlords may only take upfront costs from a tenant of up to 1 month's rent. Tenants have a right to request that they can keep a pet at their property. Landlords cannot unreasonably refuse this, although they can require that the tenant maintains pet insurance for the duration of their AST. For student rentals, these ASTs will also move to being periodic tenancies. However, there is a specific eviction ground 4A under Section 8 for houses in multiple occupation let to students, which will allow landlords to regain possession in line with the academic year dates. This will require prior notice to be given at the start of the AST. Looking ahead, there are a range of enforcement powers for non-compliance with the 2025 Act. Civil penalties include fines of up to £40,000, rent repayment orders, and widened investigatory powers for local authorities. Later phases of the Act will come into force, so from the 31st of July 2026 will be the deadline for final applications to court for possession under Section 21. In late 2026, a PRS database and PRS Landlord Ombudsman will be introduced. The former will require landlord registration to help councils target enforcement of the 2025 Act and for tenants to verify compliance. The latter will provide a free and binding resolution service for tenant complaints, avoiding the time and cost of full court proceedings. In April 2027, end-to-end digitalisation of the court process is planned. In 2028, mandatory sign-up to the PRS Landlord Ombudsman is planned. In 2030, there is a mandatory EPC rating of C or above, and in 2035, an application of the Decent Home Standard to the PRS. So how should you advise clients? As a chartered surveyor, how might the Act affect your advice to clients? Think about these questions. Are your landlord clients compliant? Does every tenant have a written AST stating the mandatory requirements under the 2025 Act? Are rents reflected of the market, and do they cover the additional costs of compliance under the 2025 Act? Are any tenants currently breaching their ASTs? How do you record communication with tenants? Are you recording sufficient information to rely on in case of a Section 8 notice is required? Are you aware of any maintenance issues through routine inspections? Are you marketing properties in compliance with the Act, for example, advertised rent? Are you discriminating in any marketing material by stating no DSS or no pets? Does your marketing encourage bids over the advised rent? And do you need to update terms and conditions for letting instructions? Thanks for listening to this week's Property Elite podcast. Head to our website to check out the full blog, and here you will find free and paid support resources and services. We offer a free consultation for every single RICS APC and Associate RICS candidate, or you can ask us any questions you have via the online chat. See you next week.